Hello, everyone. Welcome to the webinar. I'm going to give us a minute here as folks file in before we get started. But I'm glad that everybody could make time to be with us today. We have over 200 registrants, so a big group, and we're excited to address this topic with you. Once we get to 100, I'll kick it in. Okay. All right. Well, there we are. So, hello, everyone. Welcome. This is Smart Contracts in the Age of AI, Insights for Scholarly Publishers. My name is Kevin Lomangino, and I'm the Director of Consulting at KGL. I'll be your moderator for today's discussion, which is designed to provide practical insights for societies on how to think about AI provisions in your contracts. And we wanted to address this topic because, frankly, it's something a lot of our society partners are coming to us and asking us about. There's a lot of great content out there related to how AI works, how it's being applied throughout the publishing process, but there's not a lot of content advising societies about how revenue models work, how societies should think about risk related to AI, how to thoughtfully protect your intellectual property, and what terms bear consideration when you're thinking about your agreements, whether that's with authors, publishers, tech companies, or other partners. All right. Hang on a sec. All right. No, back to the previous slide, Mike, please. All right. So from KGL's perspective, AI isn't coming. It's already impacting every corner of the publishing enterprise, from how papers are written and edited, peer review and editorial workflows, and contracts and licensing. So it's no longer a question of when will we feel the impact. It's already happening, and it's no longer something you can choose to ignore. And our guidance to our society partners is that they should be thoughtfully but actively engaging with it. In our view, this is going to be yet another transformative shift, and I know we've already been through many of them, and it's one that you're going to need to navigate through experimentation and taking calculated risks. So the question is, how do we approach these decisions? How can we protect our values while still evolving with the technology? That's what we're here to explore, starting with some key areas where we think publishers and societies need to pay close attention, and I've listed some of these on the slide. And we have a great panel of speakers who are going to be talking about some of these areas and others. So let's move on to the next slide, please, Mike, and we'll have some quick introductions. I want to thank our remarkable panel of speakers for joining us today. This is truly a distinguished group of experts, and I'm really looking forward to hearing all of your insights. First up, we'll have Roy Kaufman, who is Managing Director of both Business Development and Government Relations for the Copyright Clearance Center. He's also an attorney, and prior to joining Copyright Clearance Center, he was legal director at Wiley, so he brings a wealth of experience from a legal perspective as well as a publishing perspective to this discussion. Next is Alison Denby, Vice President of Journals at Oxford University Press. She's been at OUP for over 10 years, and prior to that, worked at B Press, Wiley Blackwell, and Emerald. She is passionate about supporting the long-term sustainability of the nonprofit journal publishing community. Next, we'll have Spencer Sanders, who is a trademark and copyright attorney at Fresh IP, a modern intellectual property boutique focused on supporting emerging deep tech companies. Mr. Sanders has broad experience handling domestic and international trademarks, copyrights, and related matters, and he is an expert in the legal framework surrounding emerging technologies, including artificial intelligence. Last, we'll hear from Dr. Chhavi Chauhan, who is the Director of Scientific Outreach at the American Society for Investigative Pathology, founder and president of Samast AI, and she serves on the boards for various mission-driven organizations in the spheres of scholarly publishing, digital pathology, AI ethics, and youth education. She is herself a former biomedical researcher, expert scholarly communicator, and a sought-after mentor in the field of scientific research, scholarly publishing, and AI ethics. So thanks again to this great panel. And I think at this point, we're ready to kick things off with Roy Kaufman. Over to you, Roy.
Thank you, Kevin, and thanks to KGL for inviting me to this. I think it should be fun. So I'm Roy Kaufman. As Kevin explained, I run both manage government relations and business development at Copyright Clearance Center, which at times are completely unrelated, but when we're talking about AI, they're entirely overlapping Venn diagrams. Many of you are, I'm sure, familiar with Copyright Clearance Center. You get checks from us either directly or through your publishers if you're a society publishing with a larger publisher. We're generally known for our rights licensing. That's our origin story. We are also, at this point, we have 750 plus employees. We're involved in a lot of other fields. The ones that I think are most relevant to a society publisher would be that we manage open access agreements and payment workflows and license workflows. And also we own and support the Ringgold institutional identifier. I just want to mention, we're a little bit bigger than most people realize. Okay, next slide, please. Okay. Copyright, I've been asked to sort of give the overview on copyright and the issues that are going to be discussed often with copyright in court cases, and also to talk about licensing, which is the antidote to, frankly, losing your rights. First question is, when you think of copyright, it's actually a very easy concept. Copyright, it's the right to make copies. So the first question is, does AI make copies? This seems like a ridiculous question, except that I've been in more than one government panel where the other side will say, oh, well, we don't make copies. And then someone will say, how do you get the content from the open web into your server without making a copy? To which they say, oh, well, I make a transitory copy, or I make a this copy. Or in a US government meeting, they say, we make no copies. And the government person said, how do you make no copies? They said, well, when we're done with pre-training, we don't make copies. So, they say, basically, when we're done making copies, we don't copy anymore. Kind of ridiculous. Anyway, to explain how copies are made and where they're made, some colleagues of mine partnered with a couple academics and wrote an article. And if you're interested in this, you can read this article. It's very detailed, very long, but it's awesome. Okay, next slide. In 5 minutes, a lot of it's going to be, and here's where you go if you want to actually read more. So one of the questions is that we have 40 cases right now pending in the United States over use of copyrighted materials for training for AI purposes. Now, the cases are going to vary. What kind of materials? Was it music lyrics? Was it science books? Was it, well, actually trade books? We don't have a clean science book case. Was it newspapers? And the point about how fair use works in the United States is that fair use is fact dependent. Each case may have a different outcome when you look at 4 factors. And the 4 factors that you're going to look at are those that are listed here. This is just from the Copyright Act. I didn't make this stuff up. And the most important 2 factors, frankly, are factors 1, which is the purpose and character of the use. For example, if it's a non-commercial research purpose, it's more likely to be fair use, but not per se fair use. And if it's a commercial purpose, then it's less likely to be fair use, but not per se not fair use, because you do have to look at all the factors. And then you get into really interesting questions like, well, what is commercial? Since OpenAI is a very large company, but apparently they're a not-for-profit. With that in mind, courts also look, is this going to be transformative? Transformative is not something that's in the Copyright Act, except as an exclusive rights of a right holder to make a derivative work. However, it's read into the first fair use factor, which is the purpose and character of the use. The most important factor, though, is going to be the effect of the potential market. Now, I'm going to come back to this quite a bit because I work at a licensing organization, and courts are going to look at licensing and to determine whether or not a use is fair. In other words, this is one of those times where if you're not actively licensing your content, you're more likely to lose the ability and the right to actively license that content in the future. It's not the way the law is supposed to work, but it is the way the law sometimes does. Next slide, please. Okay, I think I got rid of this slide, but this this is an older slide deck. There you go. Thank you. That's okay. The other one is a point I'd already made, which is, when you're looking at, let's go back to that slide since it's there. Just that when you're looking at fair use, again, it's who's fair use. So in the case of Kinko's, if a student made a copy, it was likely to be fair use, but if a student paid someone to make them the copy, it wasn't fair use. Again, and just getting into the fact-determinant nature. Let's go to the next slide. Okay, we've had, as I mentioned, there are 40 pending cases, and there's one that's actually had a substantive decision, and that was Thomson Reuters v. Ross. And if you're interested in this case, I'm a chef on the Scholarly Kitchen. I wrote an article about it, so you can find that article there. But essentially, this was the first fair use case to get decided on summary judgment, and the court found that it wasn't fair use for this company called Ross to make copies of the Westlaw database in order to make a product which happened to compete with Westlaw. What's interesting is the case repeatedly states this is not a generative AI case. This is not a generative AI case. There are people on the other side said, well, because it's not generative AI, we don't have to look at it. I think because it's not generative AI, if it were generative AI, it would be easier to decide on behalf of the plaintiff. But, that will go how it goes. Let's go to the next slide. The case for licensing, and we're at CCC sitting between users, mainly corporations, sometimes academic institutions, and the publishers. And what we know is there are 40 cases in the US, and they're going to go in different directions. And there are text and data mining exceptions in the UK and the EU and Singapore and Japan, and they're all slightly different from each other. And then how that applies to artificial intelligence is an open question, subject to debate. And if you are a user, you just want to know you can do what you can do. Our users tend to be highly compliant corporations. They come to us and say, just give me a license. I don't know what our researchers are using. I know they have lawfully acquired content from various publishers. Please let us have a license. That just gives me a standard set of rights, so I don't have to worry about what the law is in the UK for my UK subsidiary versus in the US for my US subsidiary. Then most countries don't even have laws on AI. Some of them have text and data mining laws. We don't even have that in the US. The other point in the case for licensing is not a bullet point here, but it supports ethics. And what do I mean by that? I mean the ethical considerations of right now, the AI companies have admitted that they're using pirated data sites, and they've admitted that they're using preprint servers, even though you think that you've retained the rights to what's in those preprint servers and PubMed, even though you've retained the rights to what's in PubMed, unless you've published it open access. Doesn't matter. They're using it. But what they're not using is the version of record. They're not using the versions that may have pulled out retractions or noted retractions. So if you're thinking of this from a society perspective, one reason to license above and beyond all the other reasons to license is that you can control what version, hopefully, of your articles are being used, because they will be using your articles. That's not, the day of them not using, not infringing, that doesn't happen. Okay, let's go to the next slide. Just to, this case, just to get back into why licensing is important, that concept I said, if you're not licensing, you're putting your copyrights at risk. Why is that? Well, here's a case that favorably cited CCC. There are plenty of cases that cite other licenses, but in this case, the defendant said, I shouldn't have to go to every scientific publisher and get permission to make a copy. And the court said, yeah, but that's not the facts in front of you. Facts in front of you are there was an easy license from CCC. And since you didn't buy that license, it's an infringement. It is in fact okay to say, well, it's, unauthorized use is different based on the ease of getting a license. Let's go to the next slide because I'm running low on time and promised I wouldn't do that. How is CCC responding to this? Many of you on this phone probably are already participating in our AI addendum to our annual copyright license. So this was our first collective license specifically to support AI. Again, the corporation said, give me a product so that I have the best available compliance product I can. Our researchers are doing things with AI. We don't really know exactly what. Get us this license. This is internal reuse of lawfully acquired content only. So it's not pirated content, doesn't train LLMs for them to resell, and they have to have lawfully acquired your content. Either it was open access or they have a subscription. More recently, we announced our systems training license. This is more of what people think of when they think about licensing AI. This would be for, to license sort of an open AI or a Google to train an LLM external third-party product. In RightsLink for Scientific Communications, we support all kinds of license choice, Creative Commons licensing. I think someone's going to talk about this later. When you publish under a Creative Commons license, you're licensing AI. Full stop, it's happening. CC BY is broader than CC BY NC, but you are in fact licensing AI, and we help publishers and authors choose those licenses. I'm going to have to skip society contracting considerations other than to say, I do believe that, if you're publishing with a large publisher, give them the rights, make copyright licensing easier so that we can protect the ability to license copyrights in the future. CCC has tons and tons of resources. I've only scratched the surface. You can get some of them there. And I think that is my last slide. And hopefully you guys will have questions for the Q&A period afterwards, because I know I went super fast. And over to Alison.
Thank you, Roy, and thank you, Kevin. For those of you who don't know me, I am, as it says on the screen, the Vice President of Journals at OUP, but more importantly, represent about 500 journals across nearly every discipline, and there are definitely discipline considerations in some of these questions, as well as about 300 different societies. So the core of our business is society first, and managing your or society contracts is one of the critical elements of what we do. So thank you, Kevin, for engaging with us in this conversation. I'm looking forward to participating. I first wanted to start with a quick qualifier in talking about what we're talking about here in contract controls. There are many versions of AI, and in this conversation, I think we want to focus on, as Roy has characterized, the discovery landscape and the use of AI to find and reuse content, represent content, rather than, as you might always also be having in conversations with some of your publisher partners, the use of AI in production processes and workflows. I think that's a whole other seminar that we could talk to. So just give you that qualification when we're talking about what we mean here in terms of the society contracts. And I'm also going to talk in the perspective of a publishing contract between a society and a publisher like OUP. So I think Roy's captured an awful lot of this in the sense of why it's very critically important to consider AI use and managing it most effectively. We know the discovery landscape is changing really, really quickly. How people are finding and using content is evolving. We're already seeing ChatGPT as a referrer overtake some of the smaller platforms like Bing, discovery platforms, and we expect that to continue. So we know people are going to these tools to find information of all sorts. It started very much in a consumer landscape, but it's quickly moving into nearly all aspects of content. So what we want to make sure is we get the right content to the right people in the right ways, so that they are acting on highly qualified, good content to get as good answers as possible. So really, it's going to be very essential to engage as societies in discovery tools, licensing opportunities, to make sure your content, the content in your journals, is found and used, which will also lead on to its financial viability at some point as we see the different business models evolve in terms of how we see revenues flow for journals, or at least be defended by journals. I think the other thing I think is important to mention here is we're looking very much to support the stakeholders in the system with our contracts. That's our society stakeholders, but also our authors. Authors effectively publish in journals because they want their content to be found, used, and built upon to advance research. So if you look at that fundamental question as well, I think it's very, very important to make sure that that content is represented effectively and carefully in any license deals or in any AI discovery tools. So what we need to think about is, what do we do then in terms of how do we approach these different deals? And I think what Roy has said and Kevin started, it's not really a choice of if, it's when and how. We really want to support making sure that this content is available and used properly. We've started with many training deals. So the first evolution of license requests to us as a publisher have been very much for training. That means all the content is ingested into a model and then used to train that model. The content is not then surfaced and shouldn't be able to be summarized or found in whole or even in significant part. So that's a very different use case in terms of helping models find the right content and lead to answers. So that's really very different to what we're now moving on to, which is much more RAG-based, where we're getting requests to be part of very specific subsets of content, say medical, for example, say in a pharma company, where they want to get right into the detail of the content, understand that content, and be able to potentially summarize or use parts of the content to derive answers either within their organization or more broadly. I think the question here is, what are the guardrails that we need to put in place around these two very different use cases? So for training, one of the key things we want to make sure is we're working with reputable companies. So when we know a model is being trained, we know it's being trained on content of like quality and ideally fully licensed in the way Roy has described. So we have many of the technology companies coming to us who want to work with publishers, support copyright, support society publishing, and are prepared to pay to license. So we can therefore put some guardrails in our contracts about how that content is used, how broadly it can be used, where it can be used. And we also want to make sure that it's with like content. So as best as we can manage, and I know this is an evolving landscape, hallucinations are limited in those models. So we're not licensing to all companies, and we're being very careful about which companies we want to license to ensure that credibility. When we're moving into licenses that might involve summarization of content and or part or whole sharing of content, the key elements for us are making sure that then we can link back to the primary content. We want to make sure citations are there, attribution is there. And the reason for that is we need to make sure that anybody who's using that content is going back to the source as appropriate. Just as many people historically in the research community would have used abstracts, we're seeing these summaries as a way into the primary content, ways to do literature reviews, to help kickstart a process of research, or to develop a deeper understanding of a subject, to think about how it might be evolving and potentially test hypotheses for future research. Very, very critical, therefore, as I just said, to make sure that the citation and attribution, and going back to Roy's point, version of record is really critical here for that research integrity cycle of corrections and retractions all being recorded against that type of content. So two extremely different use cases to give you a sense of the types of deals that we're looking at and people are approaching us for. They're coming to publishers, and this is back to the point of why we hope that all of our societies will enable us to act on their behalf to license, or at least support us doing that. Most of our contracts allow for this in terms of our broad derivative rights and licensing rights. We don't want to explore or exploit that without our societies being on side. So it's very critical for us to engage the community and make sure that everybody is comfortable with what we're doing and why. And really what we want to do there is make sure that you are getting, as a society, financial compensation according to your contract. We're protecting everything that we can to do to preserve copyright, as Roy has said, and we're getting the content in the right sort of tools in the right sort of ways. Another thing in your contracting with publishers, so basically we're asking you to allow us to do this as part of our responsibility for representing your content and its commercial value. The revenues in our cases are always shared per our normal contract, in terms of we have a different revenue sharing arrangement with every one of our different societies, so the revenues are considered as part of total revenue, upon which you might be paid royalty or profit share, and we really want to make sure that we're exploiting this revenue on your behalf where it's possible. And our fear or worry is that it's going to be very important in terms of preserving total revenue as discovery changes. We're already seeing the shift in usage. Since we've seen the sort of AI summaries on Google, we're seeing usage move away from the direct platform into alternative models. And so this is going to be a way to make sure that you retain the revenue and value and impact and dissemination of your content. So we think it's very important for you to do that. It's also the case that you need scale. We've had some of our societies ask if they could do this themselves. And of course, that presumably is possible. We can negotiate contracts around that. What it will do for us is diminish the value of that contract and potentially what we can offer to a society in terms of financial returns. But also, more critically, all of these companies are looking for high volume. They need to work with publishers or central services like CCC who can represent massive content. They can't negotiate deals with every small society or even mid-sized society. So it's moving in a very similar way as we saw the library market move from individual subscriptions to collections to read and publish deals, where whether we like it or not, scale is really critical to enabling some of these deals and representing this type of content through these different licenses. So my plea here is work with publishers that you trust, talk to them about what they're doing, make sure that you understand how licenses are being used and ask about the financial distribution of any revenues that are being generated from your content, but support them, be open in accepting the idea that this is just another version of what we do to help really present your content as broadly as possible and ensure that you get the full value that you can from its distribution. Happy to take questions at the end, but at this point I will move on to Spencer.
Morning, everybody. I'm Spencer Sanders. I'm a trademark and copyright attorney at Fresh IP PLC. We're a boutique IP firm. We represent all various clients from small all the way through the big companies. I'm sort of coming from an outside looking in perspective. Most of what I'm going to be talking about is sort of what I'm seeing as a lawyer in the space discussing AI and copyright, as well as sort of what we as lawyers are going to advise our clients going forward and sort of to avoid certain pitfalls and litigations. So the first thing is trust in AI. So obviously the more prevalent AI use becomes, the less trust readers have of academic writing. That goes for creative writing and news as well. I don't have any specific legal examples other than the 40 plus cases that Roy mentioned to sort of talk about trust, but I do have I can go to academics and I have some more antecedent evidence, right? We have research published in the Computer Methods in Business Biomedicine Update, Volume 5, 2024. This conducted research by various institutes in Australia, was a systematic review of 24 studies in various databases since 2019. The research showed a number of positive uses of AI, such as brainstorming, review and synthesis, data management analysis, editing and review, all great things to use AI for. But the study clarified, however, that if not careful, there could be underlying issues with maintaining academic integrity, way too much reliance on these tools, such as the use of inaccurate information or combination of opposite findings or data published in various forms, also from unverified or non-peer-reviewed sources. Could lead to inaccurate or bad data used in writing or creative writing, which could cause trust issues. You could also look at antecedent evidence like the Google AI answers, for instance, asking for how to help support your immune system. At one point, it was responding, eating your boogers could help, or for I want a good password, a memorable password, I suggest using your name and birthday, which is obviously opposite data. So the trust in AI is an issue. So I think likely what we're going to see is contract language going forward, contract language ensuring reasonable steps taken to ensure the validity of the information presented. So we're likely to see something taking the onus off the publisher for interactive information in regard to the use of AI. And what I mean by that is, from what I've seen, these publisher contracts are going to have language requiring societies or authors that are self-publishing to verify the accuracy of the presented data and the ownership of the content. So ultimately, the drafter, which is usually, but not always, holds more power, will attempt to shift the liability off of themselves. So if there's a dispute regarding the information contained within the work, they can point back to the contract to mitigate liability. So what that means is that societies and authors, and even publishers, need to be aware of the steps of what's performed to ensure that they are safe from the legal implications of the use of AI. Whether that be copyright infringement, misrepresentation of data, that leads to reliance and some form of harm, whatever that may look like to the reader or to the user of the information. And for societies, this probably means, contract language with the authors, as well as careful reading of their requirements from the publisher side. Societies are going to need to sort of verify that their authors are not using or responsibly using generative AI, if they're using it at all, to write their works. For authors, that means reasonable use of AI, and then careful reading of all your contracts. So we have to see an insurance that everybody's on the same page, which, explicit details of what AI tools can and cannot be used in writing and editing. It's obviously a contentious matter in the world of publishing, and reasonable minds are going to differ. Because of that, every party involved, whether that be the publishers, societies, authors, need to sort of be aware of the expectations along the way of how AI tools can be used. Authors need to be aware of whether societies are going to not allow generative AI, or if they're going to allow generative AI, how they're going to allow to use it. And is disclosure going to be required? Are you going to have to disclose where you're using AI tools, how you're using AI tools, and sort of understanding what you need to do to be in line with the contracts from both your societies and the publishers, and vice versa. You can go to the next slide. But what we're seeing, the main thing we're seeing is an increase of publishers and AI deals. So we're seeing publishers signing contracts with AI developers to use the content in LLM training and learning. So academic publishers are increasingly announcing these deals with publishers, and many without express permission from the original copyright owners. That's sort of, a question that's in the air about whether or not that they're required to gain explicit permission. But I think we do have two main concerns within that do have clear patterns. Those being remuneration. So publishers have any publishers that have announced deals with AI developers have also announced remuneration for the societies. And those, what I've seen, have been done in sort of three ways: either lump sum, so in a set amount that allows use of the content once in an AI training model. So they're paying the content owner the one time for the use to train the AI model. We have royalties based on usage, which is content remains available for the use of the LLM to pull from whenever necessary based on the user's prompt. And then a set payment is made for each instance of that data, the data that contains that content being pulled by the LLM. Or fixed lump sum, which is a license to the AI developer of the content for a set period of time for use as necessary. This sort of opens up the fact of of renewable or non-renewable terms. So whether or not the data is going to be renewable for a certain amount of time or non-renewable, if the data becomes out of date or unnecessary. And then citation. So obviously, there's concerns from authors, societies, and publishers regarding the citation of works and content. And I think many publishers have shown a considered effort to work with AI developers to ensure correct and accurate citation. So in an attempt to quell concerns author societies may have with their research and effort being lost to AI summaries, we'll likely see within licensing agreements ensuring reasonable attempts to require clear and properly cited work when applicable. It's not really possible for me to provide exact language without having direct access to these agreements between the publisher and the AI developers. But what I can say is that the language will vary based on how the AI system functions, how the data and content will be used, and therefore how sort of the citation will be necessary. I do have an example a little bit of some of this language. I just didn't think it was worth to go into the weeds to discuss specific language. And we can move on to the next slide. So the application of current contract language and sort of how it affects the legal landscape, right? So all my discussed topics, this is probably the most affected by the changing landscape. And as Roy mentioned, there's numerous cases currently happening that are bound to alter the legal application of this. So I'm going to approach it as best I can from the current application of copyright and contract law and discuss how I, as an attorney, sort of will position my clients to best avoid legal issues. I would argue that the right to publish does not equal a right to provide to AI developers. So although some agreements grant broad legal rights to the entire work, and that's obviously those contracts exist. I'm talking about contracts that don't necessarily grant the entire license, that are just merely a license to publish the work. These agreements to publish are exactly that. They're a license to publish and nothing more. So I think this language is likely to be broadly interpreted as granting the right to provide is unlikely to be broadly interpreted as granting a right to provide contract to AI developers. It's going to be a license to publish, and the AI developers are going to have to obtain that right exclusively. Subsidiary rights do not include AI rights. So some argue that subsidiary rights, which are oftentimes within contracts, if they're well written, have their own section in agreement and are specifically listed, cover AI rights, right? I would say that, however, most of these clauses do not typically specifically grant the right to sell or provide the content or work to AI developers. And even further, that authors retain any rights that are not explicitly granted by these contracts. So I have typical wording here on the screen that sort of shows what what this clause would look like. With a shift in licensing contracts likely explicitly moving to include these types of rights, everyone involved should be careful to ensure they are either maintaining these rights if they intend to, or granting the rights they have legal right to grant. A society cannot grant the AI use rights to a publisher if they haven't properly obtained them from the author, and a publisher cannot sign a deal with an AI developer for rights they don't hold. A possible legal loophole with this is fair use, obviously, and Roy discussed fair use at length, so I'm not going to. But I think the obvious issue with all of this is that fair use becomes a standard application. If fair use becomes a standard application in relation to AI training, these rights would not be legally required to be specified in an agreement. But practically speaking, I think until all fair use questions are fully fleshed out and answered, to avoid both costly litigation and to maintain trust and cohesion in the industry, I think we're likely to see a shift in AI-specific clauses at every level, from publisher to society and from society to author. Move on to the next slide. And the key takeaways here are obviously everybody from publishers down to authors need to read their contracts carefully. They need to ask questions regarding the use of AI and how it affects their contracts. Hire legal counsel. I think it's very important to have a lawyer look over. People can get lost in legalese and not understand what rights or privileges they're maintaining or giving away. And then staying informed, attending these sort of events and trainings. And it's important for everyone whose role it is that even transitionally relates to AI and copyrights to be knowledgeable on how it is likely to affect them in their field. And I didn't think it was helpful to sort of use of our time to go over specific language. But that being said, if anyone thinks that seeing specific language would be helpful or beneficial, feel free to reach out and I can absolutely provide some of the specific language I'm talking about. And then we can move on to Chhavi.
Thank you so much, Spencer. So it's going to be a little challenging to follow up on those three insightful takes, but I'm going to take a stab at it. Next slide, please. So previously on this webinar, we've heard about copyright, licensing, shifting content usage, balancing rights and revenues, and as Spencer just now covered, AI tools and training deals and such. But how do all these actors and effectors play out in action? And I guess the billion-dollar question is, how do we as small, society publishers and publisher partners secure our bottom line? Next slide, please. So if we say that our broad storyline is based on 4 premises, ownership, we discussed this extensively so fast, cost in terms of revenue, how do we secure our bottom line, policy and preservation. But we have to come to terms with the basic premise of two dramatic opposing forces that are always playing into action here in the background. So the authors and researchers, they always want to make their research openly available and freely available, as widely disseminated as possible. But as societies and publishers, we want to make content proprietary and put it behind paywalls of sorts to monetize the content and generate revenue. To add a little bit more drama to these opposing dynamics, there are several actors and effectors, as Roy mentioned, Alison mentioned, and Spencer mentioned before. I do want to bring about or point out a couple other factors without getting political, the global variance in policies and regulation that we all may have to deal with in terms of copyright and licensing as this field evolves. Digital rights management. Roy mentioned in his talk about fair use. So there are nefarious characters who may not be using or fairly using the content. And quite honestly, and I believe both Roy and Alison mentioned that, the really murky copyright enforcement that is currently available. Next slide, please. At this point, I would like to introduce our protagonists, the societies, right? The key role of the societies is to be able to achieve their missions by supporting their constituents. And I've listed some of the constituents here that need to be in the know-how and be informed and be a part of the copyright and licensing deal directly or indirectly. Moving on. So there are three different flavors of societies. Like ASIP, which is society published and partner published. There are other societies that are exclusively partner published, and there are certain other societies and smaller societies that could be self-published. Moving on. So for societies in general, it is critically, and this applies to all three genres of the societies that I mentioned before, it's critical for them to align their decision-making, keeping in mind their missions and the values of the society, while carefully deliberating on the communities and the constituents that we serve. And this protagonist has to function within the confines of all the good attributes associated with it, maintaining transparency in your policies, accountability, always having a human in the loop, and also thinking about accessibility of the content with a futuristic twist in mind to make sure that the content is accessible both to humans as well as machines that would be consuming it. So we really need to focus on developing standards, focus on provenance markers, and focus on persistent identifiers. And our protagonist has to do this and achieve this all while maintaining public trust and ensuring sustainable reproducibility of the scholarly content. And at this point, I do want to thank FASEB. ASIP is a FASEB member society, and FASEB has provided guidelines to navigate their members through the licensing and copyright process. Next slide, please. So partner published. So same principles essentially apply to the partner published societies as well. But as it was mentioned before by Alison and by Spencer, touched upon by Spencer, they have to deliberate definitely on the revenue models within the defined parameters, really understand the contracts, the terms, the language for what they are worth. Ensuring that the content is included in relevant licensing deals, not just now, but going forward. Ask the right questions. How will they be informed about new opportunities? How those opportunities may be communicated to them? Next slide, please. For the self-published societies, they have even much more little wiggle room, and they have to definitely put their stakeholders front and center. And I would like to say that they would have to explore partnerships meaningfully. So just to add some fun and dramatic decisions, like choosing whether they want to opt in or opt out of the deals based on their impact on science at large, or whether they want to explore other aggregators depending on whether or not their values align with their own missions. Next slide, please. As we approach the climax, we have to critically think about who would be the rightful rights holder. I know we've already extensively talked about the society being the rights holder, the publisher being the rights holder. But I want to add a little bit of twist to this story. You know, we in the scholarly publishing domain just continue to follow the suit that we have established over the course of centuries, right? Would we in this domain maintain the current copyright standards of rewarding the societies and publishers for the content, or pivot to follow the trends from other societies and other industries? I know Spencer mentioned about author being, you know, the owner, but at the same time in different forms, right? So I'm thinking about entertainment today. So if the content producer still holds the right to the original content, my question to everyone here is going to be, are we going, or are we going to go too far if we perhaps consider our authors or researchers maybe the final rights holder, especially in the emerging fields where they start relying on reporting research, extensively using cost-intensive AI-generated content? And if that is the course of action to be followed in the future, how would that affect our bottom line? I guess we'll have to watch this movie in full to see how the story plays out. But for now, I'll stop here. And thank you all for joining us today.
Great. Thanks, everybody on the panel, for those excellent presentations. I think we've got time to get into some of the questions that have come in via the Q&A and the chat. So first off, a couple of questions related to open access licenses, and specifically, does publishing with the CC-BY-NC prohibit the use of articles for AI? And then sort of a follow-up there, if publishing open access allows AI companies to legally use the work for training without permission from the society or publisher, does this also allow preprint versions to be published that are published by universities and green OA repositories to also be used similarly? I have a feeling, Roy, you might be best positioned to tackle this.
Yeah, you're going to have to repeat the second one, but let's
Okay.
start with the first one.
All right.
So, first of all, if fair use applies to the training of AI, which again, we've had one case against a commercial entity and it didn't apply, then it sort of doesn't matter which license you attach because the licenses are trumped by the fair use concept. Let's put that aside because I don't think that's always going to be true. CC by NC, that allows non-commercial uses without further licensing. Remember, it is a license. You don't need a second license. Thus, I would believe that CC by NC allows you to make certain AI purposes as long as it's non-commercial. Then we get into how do you define non-commercial? I think if you're an academic institution doing research, okay, that's non-commercial. If you're open AI with a not-for-profit status, does that make you non-commercial? I doubt a court would really buy that, but there's that argument. And then there was a case in Germany where, and this is pretty common, where the academic institution did the text and data mining and then gave a finished AI product to a commercial entity, and how does that interact? So there are no easy answers here, but those are the ways that I would analyze that. I will get back to my first point, though, which is when you have a license, you can prove that there is a license. That's something that courts, at least in the US, look to. So if someone makes a commercial reuse and you say, look, I have a license, but it's CC by NC, you've really expressed that you don't want those commercial reuses without the consent. And I think that's beneficial for you in the event of any dispute. Or say another way, if I'm a highly compliant company who wants to use AI, I could be an AI firm, I could be a pharma company, I want to comply with copyright, I would probably stay away from stuff that says NC without getting a separate license and separate permission. the whole buy question, the attribution question, is a very fascinating one. There is a pending lawsuit involving open licensing, not CC licenses, but GNU licenses, as to whether if you're training and don't have attribution, have you violated the open license terms? And as Alison pointed out, you don't really do attribution in training. Attribution makes a lot of sense in RAG, makes a lot less sense in training. So I'm going to ignore the whole buy requirement for purposes of this discussion and just say, the most restrictive licenses you could use are, well, copyright all rights reserved, which is not a license, or if you use CC BY NC and D, then that covers, also doesn't allow derivative works to be made without consent. So I hope that answers the question. It's a very nuanced response to a very nuanced challenge. I don't know if anyone else wants to pipe in on that, Spencer or one of the people who's more directly related in offering these licenses.
Would either Alison or Chhavi have any feedback on that?
Well, I have an additional comment and question of my own, really. Being a society publisher, and we didn't have to do that, right? Our content was proprietary to the journals we are managing. But lately, we have opened up to the idea of accepting content that has already been staged on preprint servers, right? So going back again, Roy, of your mention of the version of records and how the content may be used by the AI tools from one source versus the other. So even if we are licensing or maintaining copyrights for the content that we are publishing, but there's all these versions of records that exist on the preprint servers, which could be scraped or used by different AI tools. Like, how do we navigate the process of attribution that Alison emphasized on through these murky waters?
Well, yeah. So if you are putting versions of record in preprint tools, my advice is enter into every license on the other side you can possibly get, because they're using your content anyway. And even when you're non-version of record, the author accepted manuscript or even author submitted manuscript is there, we know they're scraping preprint servers. And in fact, not going to name a large tech company that tends to be very pro-copyright, actually did a paper and said, oh, just to show you how pro-copyright we are, we only use these data sources, and they listed PubMed Central. Now, we know that if it's a PubMed Central article that's published CC BY, they probably could do that, but a lot of what's in PubMed Central is CC BY NC, or in fact, all rights reserved, but this highly compliant organization felt like, oh, I can use it because it's in PubMed Central. And believe me, PubMed Central puts no regulators on whether you're a commercial or a non-commercial entity. They say, that's your problem, not mine. So, it gets back to my point on licensing, which license with us, license anywhere you can, because you have no control. Your stuff's being used. The only thing you get by not licensing is nothing. So that, I don't know if that partially answers your questions, but I also would not, unless you're getting paid under a CC BY open access thing, I wouldn't put the version of record on a preprint server, because I know STM and some others are working on ways of attaching retractions and corrections to things out there in the ether, but until that's really, really well done and smooth, it just makes me nervous from a content integrity point of view.
I could
Yeah,
add
Alison?
just add a tiny little bit on the CC BY at least, or at least whatever license. What we found with the larger organizations where we feel we've got good trusted relationships is they're prepared to pay for all the content we have, regardless of license. And I think in part because they really want to make sure that they've got the most up-to-date version, the most credible version, the version of record. And they recognize, the convenience of us doing that. Now, we've anticipated that maybe there might be different price points for different licenses for some of the training tools. But I think, and going back to the Chhavi's point about all the content improvements, we know a lot of companies have scraped pretty much everything we've got somewhere or other. What I think is going to define the future is working with the companies and we will all want to use the models built on trusted material where you can understand the provenance of that material. So I think that's another really important point for us to think about. We're still at the frontier a little bit at the moment. We've seen all the problems associated with the hallucinations and poor quality content and quality control in content. I think the next evolution of value to each of us as a consumer in whatever guise we are, and whatever level we want to consume content, we're going to want to know where it came from to some degree and that it can be trusted. So I think that's the other thing that we're very much focused on, choosing partners who have that same objective in mind. Maybe I'm being idealistic, but I think we've got to look to the need for quality content to be represented effectively, and not alongside random stuff scraped from the web.
Great, thank you, Alison. So a more basic question, and maybe Chhavi, you could take this one: the difference between training and RAG. Can you succinctly explain that? Is that?
I want to rely on what Roy said first on that too, because Roy, I think there are different licensing principles that you would want to apply to training material versus RAG models, right?
Yeah, I mean, I just feel so training this. Here's my non-technical thing, because I'm a lawyer and I've never written a line of code in my life.
I'll come to the technical part next.
You take a whole bunch of content and you put it in a blender. And what comes out is, AI as a statistic predicting machine. It's not a source of truth. It's nothing like that. But you're trying to say, well, how does, what words follow these words? And so when you're licensing for training, the output is just how the AI works. So there's no place to even put a reference. It doesn't really make sense to say, well, these two words came from this article. It's just everything goes in a blender. RAG, I think of as almost, a colleague refers to it as enhanced search. So, what happens when I mix this chemical with this chemical? Here's a reaction, and you want that reaction to be useful so it's not, made up by the AI. When you're thinking about where credit makes sense, well, you can say, I always want credit in everything, including when it goes in the blender. But when the blender doesn't actually compete with the output the way RAG actually competes with the output. So, do you want credit or do you not want credit? Because if there's no credit, then they still have to come to the version of record, because that's where the source of truth. Again, when we think of AI, it's not a thing. It's a million different things. It's a million different technologies, and what license and what considerations apply vary based on the specific use case.
Yeah, so Kevin, when you ask about the training data set, it could be wide, right? It could still be proprietary for the publisher or the society, but it could be broadly based on the content that's out there alongside, the field that we are talking about. With RAG, it's more refined, and I'm just thinking in terms of licensing that we were talking about, and attribution that Alison mentioned, and also one aspect that we didn't talk about, the timelines for these licensing agreements, right? So some of the emerging fields that we are seeing with the use of AI for our journals, the field's emerging so fast that the licensing duration comes into play, because the content is evolving so fast. So that's where the RAG models become a lot more important, because your field is evolving. The training material that you're going to feed into these AI models has to align with the new developments that are happening there. And the RAG output becomes a lot more valuable there than the generic training data set. I hope that helps.
Yeah, I think it does. Thanks, Chhavi. Okay, maybe one last question here. Spencer, there's a question about remuneration. How would publishers identify LLM usage for a royalties based on usage model of payment?
Yeah, I think that difficult question in the sense that it really depends on how the LLM functions or works, in the sense that it's probably going to be contract based, very, very explicitly stated in the contract how data is going to be used and how the AI developer is going to sort of track what data is pulled and how. I think it's tough to sort of for the publisher to know how their data is being used or where it's going to be without just trusting the AI developer to tell them when their data was used and how it was used. It obviously differs based on, you know, RAG versus a training model. If the AI is fully using a training model, how do we know whether or not the data that it spit out, that the information it spit out was used based on the original content that was licensed, or if it's a RAG model, if it's cited, we know that it was pulled, right? Yeah, publishers find the for AI companies finding the blender, exactly. So I mean, it really depends on sort of it's all contract language, and based on how the AI developer, who at the end of the day is a tech company, so they obviously understand the code and the tech a lot more than a lawyer would. Sort of telling you when the data was pulled and how it was used. Other than getting access to their database and the final product, the final like data set, it's not really possible to know without trust, and that just comes down to trust and contract language. I don't know if that really answers your question, but that's sort of the only way I know how to answer it, unfortunately.
Well, I think it's going to have to do for today, Spencer.
Okay.
Thanks very much. And thanks to all the panelists for sharing your expertise with us today. Thanks to everybody who attended the webinar. There will be a link shared later afterward for anybody who missed it and wants to, if you want to forward that along to your colleagues who might want to see what happened here, that will be available. So we'll leave it there. And obviously, as you have questions about AI, I mean, this is going to be moving at lightning speed. We're here as resources to try to help. And I think we'll leave the discussion there. So thank you.